See how I want to do this. Because there's no real video in this one. It's just the oral arguments, which is insane that they can't have cameras in the Supreme Court. It's freaking ridiculous. Let me shut that down. Forgot I didn't shut down or didn't freaking mute the YouTube stream. Now I was getting that shit echoing in my ears. Oh, fuck. So see, I'm going to give it a couple more minutes and see whether anybody bounces in, and then I'm going to get this rolling. And I'm just trying to make sure I got all my ducks in a row here. It looks like we are going out to YouTube. Check this and see. To different, trying to get used to streaming this thing to a couple different places. I'm learning. That's all I can say. All right, so to get into this is oral arguments in front of the Supreme Court in 2014. Abramsky versus the United States. Abramsky was charged as a prohibited, or not a prohibited person, but he was charged as a straw purchaser. Sorry, that's what I want to say, straw purchaser. He bought a gun for his uncle. His uncle sent him the money. He said he could get a better deal on a gun. His uncle sent him money. He purchased the gun. He transported the gun to, I think, Pennsylvania to his uncle, and actually transferred the firearm to his uncle at an FFL. So his uncle actually had a background check run on him when he transferred the firearm. Abramsky was under investigation for some other stuff. This guy was actually a cop. He was fired as a cop. He was suspected in a bank robbery. That's how, when they searched his house, they found the receipt and everything for the firearm. And that's how they found out that he had bought a firearm with his uncle's money and then transferred the firearm to his uncle. And they charged him with a straw purchase. So they start, he just basically running this guy through court, trying to put him in prison over this stuff. And it's crazy because all of the background check and everything was met. But they still tried putting this guy in prison. Ultimately, I think he pled out on it and ended up with a reduced sentence or whatever. He ended up just doing probation. So let's get into this. Let's go ahead and play this.
We'll hear argument next in Case 12-1493, Abramsky versus United States. Mr. Dietz.
Mr. Chief Justice, and may it please the Court.
So this guy, as typical in cases like this, the first guy you're going to hear is the guy representing Abramsky in this case.
2009, Bruce Abramsky went to a gun store in his home in Virginia and purchased a firearm. When he did so, he filled out all the required federal paperwork, providing his own name and identifying information and passing a background check. He then traveled to his uncle's home in Pennsylvania, and delivered the firearm to a licensed gun dealer there. That gun dealer required Mr. Abramsky's uncle to fill out the exact same federal paperwork and pass his own background check before taking possession of the firearm. But despite doing precisely what Congress established as the process to buy a firearm intending to sell or give it to a lawful gun owner in another state, the government charged Mr. Abramsky with falsely stating that he was the actual buyer of the firearm when he acquired it. And that term,
what would happen if?
Yeah, and that's right. He still transferred it, and he's fixing to start getting asked questions by the judges here in a sec. But yeah, he transferred it to his uncle through an FFL, had the background check run, and yeah, they still charge him as a straw purchaser. So this gets into how they could charge anybody with this. I mean, if you buy a gun and sell that gun later, they could still count you as a straw purchaser. There's nothing on there that says the amount of time that you would have to own or take possession of a gun before you could transfer it.
Two people walk into the gun store. One person hands.
And I think this is Sotomayor or this may be Kagan, whichever one. She's an absolute moron.
The money to the other and says, buy me that gun.
Yes, Your Honor.
Is that not actionable?
Your Honor,
according to your theory?
Your Honor, in the circumstance where there are two lawful gun owners, that is permissible. I think a good way to illustrate that is to consider the government's concession that in that hypothetical, if the two people walked into the gun store and the person looked and said, I'd like that gun, and points to the counter, and then the person
What's truthful about saying you're the...
Please finish what you were saying. I didn't understand what your point was.
Yes, Your Honor. And in that circumstance, if the person standing at the counter then says, I'd like to buy that firearm that the person indicated, I'm going to give it to that person, then even the government concedes that in that circumstance, everything about that sale is perfectly lawful, and the buyer can take the gun, hand it to that person standing next to him, who would leave the gun store with the gun dealer and the government having absolutely no idea who that person is or where the gun is going.
Because the biggest thing about any of these background checks really is the government's ability to track that firearm and to know where these firearms are at, if at all possible. It has nothing to do with stopping crimes because it hasn't stopped anybody. The millions of background checks that they say stopped a firearms purchase, the vast majority of those were false positives. And then people have to go back through and fight to get their name basically either out of that part of the system or to get their firearms rights or purchasing rights back. It's really insane what you have to go through with some of this, because most of the time that when a background check is run, it's not run like off of your social security number, not like a background check you get for a job or something like that. It's run based on similar names. So if someone has a similar name and they have committed a felony or something that would stop them from purchasing a firearm, you could possibly bounce back onto that same positive.
I'm sorry, so you're saying that in that case, the gun dealer runs the background check on the person who hands the gun dealer the credit card, as opposed to the person who will be the actual recipient of the gun? Is that what you're saying the statute requires?
That's correct, Your Honor. I think the government concedes that as well, in the gift circumstance at least. And there's certainly nothing in the Gun Control Act that suggests that Congress was distinguishing between those two circumstances.
Well, in the gift situation, but Congress requires certain information from the buyer, whatever that means, right?
Yes, sir.
The dealer has to record the name of the buyer, right?
Yes, sir.
And the address of the buyer, and do an instant check on the buyer.
Yes, Your Honor.
Now, why would this Congress have wanted those things with respect to the person who's just the straw purchaser, not the person who's actually going to acquire the weapon?
Well, because again, they're going to track the original point of sale for the firearm. So if it was ever used in a crime, they go back to the original purchaser. When me and my wife were together, just dating, if I had went to a gun store with her and decided, hey, I'd like to buy her this gun, and I purchased that gun, and then I turned around and gifted it to her, since she wasn't my wife at the time, we weren't related, they could charge me with a straw purchase on something like that. Yeah, Kurt, they get real freaking spazzy on stuff like that. I was surprised a few years ago when I bought one of the guns that I wanted, and then bought my wife a side-by-side shotgun she wanted at the same time, that they didn't try to give me shit about that.
The reason, Your Honor, is that this legislation, the way Congress designed it, is not focused on sort of the end point. It's not concerned about where a gun is actually going, who's ultimately going to receive it. What Congress was concerned about was the starting point, because as part of the key political compromise of the Gun Control Act, there were two competing interests that needed to be accommodated.
Why would they be concerned about the starting point? Let's say there's a man, Mr. Straw, and he holds himself out as a gun buyer. He puts, a website, he creates a website, he has something in the Yellow Pages under straw man, and he says, you want to acquire a gun and you don't want the dealer to record your name and you don't want to have an instant check on you, you come to me. And so these people come to him, and whenever they do, he goes to Joe's gun shop, and with the other person, he says, I want to buy a gun, but this fellow with me is going to do all the talking. So the guy who's with him talks with Joe about different types of guns, costs, and everything. And after that's done, the person who's done all the talking says, "Now my friend Mr. Straw is going to buy this gun."
So this is Stephen Byer going through this ridiculous ass argument about how a straw purchaser could just put themselves out there to buy guns for anybody, which technically, in a sense, should be perfectly legal. They are buying the gun. It's up to them what they do with that gun after they buy it. But Stephen Byer, of course, he's retiring from the Supreme Court. Biden put out his pick for the Supreme Court already, who is going to be even worse on guns than Byer ever was, which is absolutely saying something.
Gives Mr. Straw the money. Mr. Straw buys the gun. And the dealer writes down Mr. Straw's name for the 15th time that month, his address, does another instant check on it. What sense does that make?
Your Honor, I think, and to your first point about why starting points, the reason is because all that Congress wanted is to provide law enforcement with a way to trace the firearm. And if you have truthful, accurate information about the first initial purchaser, the person who walks out of a gun store with a gun in their hand, then law enforcement has that starting point if they need to trace the firearm.
I suppose that your answer to what sense it makes is that was the compromise, that there was strong opposition to any gun control law. And the condition was you get the buyer. And you don't make the buyer promise not to give it to somebody else. He could immediately give it to somebody who's unqualified to own the gun, couldn't he? And would that be a violation?
No, that would violate other laws.
Yeah, that would violate other laws. It is against the law. It is a felony to transfer a firearm to someone who is a prohibited possessor. That law is already there. That law has already been there. So, the more I look at this, the more I look at the background check system, and the more I look at where they want to go with these things, the background check system is absolutely ridiculous. Like I said, the majority of the time that they stop someone from purchasing a firearm, it's a false positive. The person has no felonies. They shouldn't be a prohibited possessor. They're just coming back because their name matches somebody else. And ultimately, where the Democrats want to go with this is universal background checks, which is the only way that they can do that and make it even halfway serviceable is to have a firearms registration database. And then they'll have to check back with you constantly to see whether you still own those firearms or if you've transferred those firearms to someone else.
Clause because Congress in the Firearm Owners Protection Act clarified that or amended the provision to provide that a private citizen who transfers a firearm to someone they know or have reasonable cause to believe is prohibited, that's a crime.
What about somebody who is qualified to own a firearm? Can I take a firearm that I own and say, it's yours?
Yes, Your Honor, and I think the government has conceded that if it's someone in your own state,
Don't have to register it. I don't have to go through a firearm dealer, right? It's my gun, and I can give it to somebody else who's qualified.
That's correct, Your Honor. And in cases like Mr. Abramsky's case, where his uncle lived in another state, Congress provided a path for those people as well, and that is you have to deliver the firearm to another dealer in that state before finishing the transfer.
You're never going to know who the end user is once the gun is sold.
No, and that's a good point. You're never going to know who the end user actually is unless you can trace every single gun in private hands. That's the only way any of this actually works. And this was just a step in that direction.
Whether you take the straw buyer's name or the other person's name or both, you don't know where the gun's going to end up, do you?
Yes, sir, that's right, Your Honor, and that's because that was the key compromise of the
language matters in a statute. I mean, I do believe that. And here the relevant language seems to me that what it's material to, the government says, is the statute about selling or delivering. Now, did this person, was he the buyer, your client? Was he somebody that they sold or delivered it to? Well, he's a straw. A straw purchaser is someone who doesn't purchase. The person who purchases is the person who uses the straw.
No, you absolute moron. When a person stands at the counter, signs that 4473, and then pays for the firearm, legally they are the purchaser of the firearm. No matter what kind of tortured logic you use, and it's absolutely insane that your ass is wearing a black robe on a court when you have no respect for the Constitution whatsoever, or personal liberty, or freedoms, or rights.
Now, you can't say that about a giver. A benefactor who's the beneficiary of the benefactor is not the purchaser. But the straw purchaser is not the purchaser. And it comes from straw bale, where someone else put up the bale. And it was called straw because the people who made a career of that used to wear straw in their shoes. Interesting. But
why wearing straw in their shoes had anything to do with them putting up the bail for something? It shows the insanity of this argument that he's got to dig so far down into this crap to try and contort this argument around to where it makes sense.
In terms of this case, the straw.
He made that up.
What? No, I didn't. I thought it came from the Wizard of Oz, but it doesn't. The fact is that is where it comes from. I think in every legal context, it means someone who is not the real. So who is the real? In this case, it is the person for whom the straw purchased. So we fit that within the language. We can't fit the beneficiary of a gift within the language, and that's the reason for the distinction, and so why not do it that way?
With respect, Your Honor, I think that the principle you described of straw men or straw purchases, in the historical context you described it, I don't believe is a criminal context, and we've not been able to find any case in which the criminal law has ever recognized that sort of civil agency law principle, that when there is a principal-agent relationship, this fiduciary duty, that because the principal controls the agent or the straw man, that everything that the agent does is really an act of the principal. And Congress, there were historically criminal common law principles of agency, and Congress codified those principles in Title 18, United States Code Section 2. Those are things like aiding and abetting, principals and accessories. But that's not the principle on which the government relies today. The government
You still have not explained what purpose is served by obtaining the name of the straw purchaser and doing an instant check on the straw purchaser. You said that it allows the tracing of the weapon, but that's not going to be true in the case of a straw purchaser, because the person who the straw purchaser isn't necessarily, and probably in the vast majority of cases, isn't going to get the name or any information about the actual recipient. That's the whole purpose of having a straw purchaser.
Let's see, that could go to his argument right there, could literally go to me selling one of my guns to someone else, and the government just doesn't know where that firearm went. He wants firearms to be tracked at all stages. He literally wants a registry. So if whether it's Kagan, whether it's Sotomayor, whether it's buyer's replacement, if the government was ever challenged on any registry system, these people would uphold the government's argument at all cases.
So then what purpose is served by this? It's just meaningless.
With respect, Your Honor, I disagree. And I think the reason is, again, that the intent of Congress in the Gun Control Act was not to trace or track where firearms were going. And so in every case, because private sales have no record keeping or background check requirements, in every case where there's a trace of a firearm, the government has to go all the way back to the beginning. They go to the manufacturer with the serial number and follow the gun through the stream of commerce until they find that gun dealer where the gun was first sold. And then
they find the gun dealer, and the gun dealer said, I sold it to Mr. Straw. And then they go to Mr. Straw. Mr. Straw said, my client took it. Okay, who's your client? I have no idea. He came in.
Yeah, well, if I meet some guy off of the street and I've got a gun that I want to sell, he seems like a cool dude, and I sell him the gun, it's the same situation. If that gun was ever used in a crime, they track that gun back to the manufacturer, serial number. Here, we'll show one off. So even though YouTube, this is a plasma cut, this is not a gun. So they find serial number on it. They find manufacturer. They go to the manufacturer. The manufacturer has tracked that gun through their manufacturing process. And then whichever FFL was actually the one that they transferred that gun to, then they go to that FFL. Then they look through that FFL's records, then they find out they sold it to the straw. You go to the straw. Straw says, hey, I don't have it anymore. I sold it. So what?
Into my store. He came, he contacted me. I didn't ask his name. He didn't give me his name. And that's the end of it. So no purpose is served by putting down the name, the address, doing the check on the straw purchaser.
But, Your Honor, again, Congress understood that that's how the statute worked because, for example—
Well, what you're saying is they did a meaningless thing. That was the compromise.
Yes, they did a meaningless thing. The background check system as it stands is absolutely meaningless. You absolute retard.
Would do something that's utterly meaningless.
No, Your Honor, and the reason is, consider, for example, a circumstance where instead of buying the firearm with the intent to resell it, 5 minutes after the purchase, walking out of the gun store, a stranger approaches you and says, that's a nice-looking gun, I'd like to buy it from you. It's perfectly legal under the Gun Control Act to sell the gun to that stranger, who then will leave, and again, in the tracing process, the government's trace will stop with that first purchaser. And Congress understood that that's how the process would work, and that was part of the compromise. What Congress wanted was accurate information about the initial person who acquires the firearm, so at least they can try to do that trace. And Congress understood that in
some cases, they can't track it all the way. In this case, unlike the hypothetical that Justice Alito gave you, if they went to the straw purchaser, he would say, oh, I actually bought it for my uncle. And he'd give the uncle's name. And then the uncle would say, where else the firearm went from him.
Yes, Your Honor. And in fact, in this case, the government received all the record-keeping and background check information that they could possibly have received. They got full federal paperwork from both Mr. Abramsky and his uncle and ran a background check on both.
Your position is that
So, yeah, in that case, if anybody showed up and didn't get the gist of this guy's charged as a straw purchaser. He bought a firearm for his uncle in Virginia, I think it was. transferred or brought the firearm up to his uncle in Pennsylvania. They ran another background check on his uncle when he transferred the firearm. So both of them had background checks. They still charged this guy as a straw purchaser and tried to put him in prison over it. It's absolutely insane.
This was not a material misstatement, is that correct?
Yes, Your Honor.
Why isn't it material in light of the fact that it was a question that was on the government form that was promulgated by, that was directed by regulations?
The reason, Your Honor, I think this is a critical concession by the government, it's on pages 35 and 36 of their brief, is the government acknowledges that the statements on the form are just an interpretive rule, and not even a sort of ordinary interpretive rule that this court may encounter with agency interpretations where they're looking at the statute, and although they have not been delegated with authority to rule make, they are interpreting the text of the statute. Here the government acknowledges that the statement is an interpretation of the case law about the straw purchaser doctrine. And the problem with that is that there's a split in the circuits about what that case precedent should be. And the government suggesting that this court should somehow defer to the statement on the form, that it has the power of law, that people should acknowledge it. But of course, when you have a case law question like this where there's a split, this court is the authority that decides what the law should be. And it's not required to defer at all to the statements on the form.
Yeah, Heath, if it was a gift to someone not listed under exceptions for these rules, then yeah, they could charge you as being a straw purchaser. So again, I use the example when me and my wife were dating. If we went to a gun store, I found a gun that she liked and I bought it for her. I got the background check done and I handed that gun to her. That puts me as a straw purchaser. That could put me in prison. I think it's if it's like a lot of others, it's a $250,000 fine and like 10 years in prison for being a straw purchaser.
Mr. Dees, could we go back to the question that Justice Alito raised? The primary object of this statute is to keep guns out of the hands of felons, of people with mental illness, and so forth. Now, it's absolutely true, as you have said, that Congress didn't do everything it could have to achieve that result, right? That there are many kinds of resales that are allowable, that there are gifts that are allowable. It's one thing to say that. It's another thing to say that at the initial point of sale, which is where the entire system is set up, right?
So you got to listen to her argument on there. She does understand that this was supposed to keep guns out of the hands of felons and criminals. This case had nothing to do with a felon or a criminal taking possession of a firearm. Her only deal is that he wasn't truthful on that 4473, so therefore he deserves to go to prison.
With the gun dealer doing the automatic checks, that at that initial point of sale, which is the centerpiece of this statute, that we will essentially disregard fronts, that we don't care that the person standing at the counter is a front. I mean, that goes far beyond the other kinds of resale possibilities that you're talking about. And I guess what I want to know is why you think a Congress that was geared towards this object of keeping guns out of the hands of dangerous people and set up a mechanism that had the gun seller be the kind of enforcer at the point of sale would have thought, oh, it's fine if a straw walks in the door.
I think the reason, Your Honor, is because Congress understood that private sales, that there was an importance to private sales between citizens. And in a straw purchase like this, or someone who's purchasing a gun intending to resell it to someone else, that is precisely what's happening, is that second sale is a private transaction between two private citizens. And Congress did not want any regulation of those types of sales, and that was part of the political compromise in the law. And so, yes, Your Honor, I acknowledge that you would certainly describe this as not a comprehensive regime. There are holes in the legislation. But remember, too, that Congress was not operating in a vacuum. It understood that although there may not be a national consensus about some of these issues, and therefore the regime that Congress chose may have some holes in it. But this
this thing has, the background check system has holes all in it. And yeah, Heath, if they spent more time going after actual criminals instead of just trying to do this crap with guns, yeah, they'd get a lot more done. If they would spend more time actually prosecuting violent criminals and keeping them in jail, this whole thing wouldn't even be an issue. But people in those black robes have upheld decisions like this many, many times in the past. And it's absolutely asinine. It's freaking ridiculous.
States could fill those holes if there was a statewide consensus on that issue, and many states have done that. Some states have, Hawaii, for example, what is really a complete gun registration system. And others, like West Virginia, believe that there should be virtually no regulation of these sorts of private sales at all. And so I think the system is working precisely as Congress intended. And if there are problems, Congress will come back and fix it. And we've seen, for example, in the Firearm Owners Protection Act and in the Brady Act, that this is an area where Congress is continuing to observe what's going on in the nation and making changes to the law as necessary.
In the situation that Justice Alito hypothesized of the person who's doing this several times a month and has the ad in the Yellow Pages, is that person subject to regulation as a dealer?
Yes, Your Honor. I wanted to make that point, and that is that, of course, if you engage in the business of purchasing firearms to sell to others, then you will at some point be subject to the licensing requirements that Congress created. So,
and see, that's another thing. There's no number listed to say if you sell so many guns a year, then you have to be an FFL. There's no magic number out there. The government can just reach right in their ass and then pull out a wad of crap and tell you that's the number.
Again, this is not a system that has some obvious loophole where people can begin to engage in their own sort of sale of guns to others. This is a situation where Congress wanted to leave open the option for private citizens like Mr. Abramsky to purchase guns for other lawful gun owners like family members, neighbors, and friends.
But this family member, the uncle, residing in Pennsylvania, he could not have purchased that gun in Virginia. Isn't that right? Because he's a non-resident.
With respect, Your Honor, I disagree. It's true that he could not have walked into the gun store and left the gun store in Virginia with the gun, but he could have purchased it there. Congress created a means in the statute for the gun to then be shipped to a gun dealer in Pennsylvania, and he would have to pick up the gun and, again, fill out the federal forms and undergo a background check at that gun dealer in his home in Pennsylvania.
But wouldn't he have to comply with the 552C, which says how somebody who doesn't show up in person can purchase a gun? And none of those requirements were satisfied here. So it seems to me that what you're asking is just an end run around what Congress said. If you're out of state and you want to buy it, this is how you have to do it.
Well, Congress makes bad laws and they make shitty decisions when they make laws. So if there's an end run around it, that's on Congress. They're a bunch of absolute retards.
With respect, Your Honor, I don't think that's what Congress meant in Section 922C, which is the provision that deals with absent buyers. And the concern there was Congress wanted to leave open two paths for gun buyers. One is to physically be present at the gun store and fill out the papers yourself, where the gun dealer, as you're writing your name and age and your height and eye color on the forms, there's a person there looking at you. And there was also an option that Congress provided for people to purchase a gun, for example, by telephone or mail or over the Internet, without ever actually being present, with no person being present in the gun store. And it was in that circumstance that Congress said, we think we need a little bit more record keeping in those cases. So that's why they required the affidavit, for example, and the waiting period to provide extra time for local law enforcement in the background check. But that's not the situation here. Mr. Abramsky was physically present at the gun store, and so that provision of the statute is not even implicated here.
Physically present at the gun store, had a background check run, had a background check run on his uncle when he transferred the firearm and still charged. And these justices are more than willing to put this guy in prison over that.
Another point, Your Honor, is that the plain text interpretation of the statute is one that the agency, ATF, had adopted initially. In 1979, the agency sent a circular to gun dealers that took the precise position that petitioner is taking here, which is that a purchase of a gun for another lawful gun owner is permissible. And in doing so, the agency said that that was an interpretation of the text of the Gun Control Act.
What is the government's, I guess I should ask the government, but does the government contend that there are two buyers now, both? Or, is the real buyer the person who sends in the straw man, so that it's only his information that you have to give? Or are there two buyers?
Your Honor, I don't know the government's position, but our position is that there is one buyer, and that's the person who's actually paying for the gun, filling out the forms, undergoing a background check, and leaving the gun store with the gun in their hand. And Congress didn't use terms like true buyer or true purchaser, actual buyer, because they were not concerned about the ultimate recipients of firearms or what happens to a gun after it leaves the gun store. The focus of the Gun Control Act is on that initial purchase and making sure that that purchase.
What position are you taking here? Are you arguing that it doesn't matter whether it's a straw purchaser or not? A buyer is a buyer is a buyer.
Yes, legally, the way it's worded, a buyer is a buyer is a buyer. This needs to be said, yeah, you're right. If they like you, yeah, you're going to skate. If they don't like you, you're going to prison. I mean, look at Hunter Biden. They have evidence that he purchased a gun, he lied on a 4473, and nothing's happening to him. This guy, which this was back in 2014, but there are still cases that are just like this that are in front of the courts where they are prosecuting people as straw purchasers, and they're going to put them in prison.
It's the person who puts the money down on the counter. Or are you arguing as a backup or as your main point? I don't understand that if it's a lawful buyer using a straw man, that's not actionable.
Yes, Your Honor. We are arguing, yes, that the person who pays for the gun, the person that's there in the gun store and pays for the firearm is the buyer. That is in fact, the term buyer isn't even used in the Gun
Even if
Control
their
Act,
intent is to sell it to a prohibited person.
That's correct, Your Honor.
And again, you dumbass hag, if they transfer it to a prohibited possessor, they are committing a felony.
And in those circumstances, again, I think this is an important point, is that Congress provided a number of means to prosecute illegal straw purchasers. And all of those provisions are still available to the government, even if this Court was to disapprove the straw purchaser doctrine in all its applications.
Well, if we disagreed with you on the first point about the straw purchaser, would you lose on the ground that Mr. Abramsky's uncle could not have lawfully purchased the gun at that store? Because
No, he could have purchased the gun at that store. He just would have had to have that gun transferred to an FFL in his own state, and it would have worked the same way. They would have run the background check on him at his FFL in his state, and they would have transferred the firearm. And why does it matter which state you're actually purchasing the gun in the first damn place? They're going to run the same background check through the same system using the same information. So someone like me, I'm just a couple of miles away from another state. It takes me no time to go from Alabama to Georgia. But I can't purchase a handgun in Georgia unless I have it shipped to an FFL in Alabama to run the same background check they would have run on me in Georgia. This is absolutely idiotic.
because he wasn't a resident of the state.
No, Your Honor, and 2 points there. First, as I mentioned, it would have been possible for Mr. Abramsky's uncle to purchase the gun in Virginia. He could have gone to that gun store and said, this is the gun I want, and paid the money. He would have had to go back. The gun would have had to have been shipped to Pennsylvania, and he would have had to take possession of it in Pennsylvania after filling out additional paperwork.
But he couldn't have taken possession of it in Pennsylvania.
In Virginia.
In Virginia.
That's correct, Your Honor. But, again, I don't think that changes the materiality analysis, because, again, the question is not whether Mr. Abramsky's uncle could have picked up or bought the gun in Virginia. The question is, if Mr. Abramsky had told the gun dealer the truth, that, yes, I plan to buy this gun, but I'm going to take it up to Pennsylvania and give it to my uncle after I deliver it to a gun dealer there. The way that Congress wrote the Gun Control Act, the gun dealer still could have sold the gun to Mr. Abramsky. That's
Or would it
why,
have been a lawful sale if the gun had been delivered to him on the spot?
to Mr.
No, it wouldn't have been a lawful sale if it had been delivered to his uncle on the spot in Virginia. However, that's not what happened here. His uncle took possession of the gun in Pennsylvania after going through a background check in Pennsylvania. That's something that didn't even happen here. Why are you even bringing up that damn argument in the first place?
Abramsky's uncle?
Yeah.
He could
Mr.
not.
Mr. Abramsky's out of the picture. The uncle goes in, buys the gun, puts down a Pennsylvania address. The dealer gives him the gun, walks out of the store. Would that be a lawful sale?
No, Your Honor. No, Mr. Abramsky's uncle could not have bought the gun in another state, taken possession of it. But again, for the materiality question.
Now, if it was a rifle, he very well could have. Being that it's a pistol, he couldn't. There are bills right now that want to treat rifles the same way as pistols that they're trying to push through Congress. But either way, it's idiotic. It shouldn't matter where I buy the gun. All that should matter is that I am a legal purchaser of the gun. I am legal to possess the gun. Shouldn't matter where I buy it. If I find a good deal on a gun in another state, I should be able to go to that other state and purchase that gun. All of this stuff is absolutely idiotic.
The way this court has described that standard in Kungas is whether if Mr. Abramsky had provided truthful information, if that would have been capable of influencing the outcome in that case.
Well,
In describing what happened here, you said that Abramsky went in and then went to Pennsylvania and gave the gun to his uncle. That's not quite correct. He transferred it to him for consideration. I had thought, and this goes back to Justice Scalia's question about if there's one buyer here or two. I had thought that it might be possible to construct a case where Abramsky tells his uncle, "I'm going to buy the gun, and then I'm going to sell it to you, and I'm going to sell it to you in Pennsylvania at a gun dealer's store so we can fill out the necessary forms." Would the government then have objected to what happened here?
Your Honor,
I mean, we can ask the government,
Yes.
as Justice Scalia indicates, but as you understand their case.
Yes, Your Honor. I think the reason is that the government's position is that you cannot buy a gun intending to sell it to another lawful gun owner.
See, and he is literally stating what the government's position is. You can't buy a gun intending to transfer or sell that gun to another person without the government's knowledge. And even in this case, when there was government knowledge of it, because he had a background check run on his uncle, they still want to put him in prison.
That is the government's position. But just one point of clarification is, to the extent it's relevant, Mr. Abramsky did not receive consideration for the purchase of the firearm. The record indicates that his uncle sent him a check to cover the cost of the gun. This was, in all respects, someone doing a favor for a family member.
Could you address the other point here, which is the one I have more trouble with, to tell you the truth? Count 2?
Yes, Your Honor. And that count, the language that Congress chose was that one cannot make a false statement about information required by this chapter to be kept.
Right.
This chapter meaning Chapter 44, the Gun Control Act itself. And the Gun Control Act contains, it actually references, there's a provision, and that's 922b5, where Congress says this is the information, it uses that term required to be kept, and it lists three things: the name, age, and place of residence of the person acquiring the gun from the gun dealer. And then ATF has promulgated regulations that have added an additional layer of information that must be included on the forms. But the government's position, of course, this question 11, who is the actual buyer, that's not one of the things that's included either in the text of the Gun Control Act or in ATF's regulations. And what the government has said in this case is, well, that's right, but we view the authorization of Congress to create the form sort of a blanket authorization to ask whatever we want in the form and make anything that we ask on the form information required to be kept.
Can you lie in answering questions that the government has no technical right to answer? I mean, let's assume I agree with you that in fact this information the government was not authorized to obtain this information, and therefore it was not required to be kept. But nonetheless, they asked it, and your client didn't just say, I won't answer. He lied. Now, can you lie so long as the question is improper?
Your Honor, I think the key in this case is that Congress included a materiality element for almost every false statement that would occur in this context. And they enacted a separate statute that did not have that materiality requirement. And the reason was Congress wanted to be sure that that provision that did not have the materiality requirement only applied to the false statements that Congress thought were the very important ones. And therefore, they delineated what that category of statements was. And the question on the form is not one of them. And that, Your Honor, is the reason why Mr. Abramsky cannot be convicted under that provision. I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel.
So now we're going to get into the government's lawyer and the government's case, which is absolutely maddening, to say the least.
Mr. Palmore?
Thank you, Mr. Chief Justice, and may it please the Court. I think it would be helpful if I could, at the outset, frame what I see as the issues here, because as some of the questioning revealed, Petitioner is making two separate arguments. His first argument is, in a sense, that there is no such thing as a straw purchaser doctrine. I take that actually as a falsity argument. He's saying, when I answered that I was the purchaser, that was a true statement because I'm the only purchaser who counted for purposes of the statute, because I was the one standing there and I was the one filling out the form. His second argument is an alternative argument, as I understand it, and he says, even assuming I'm wrong about the first argument and that this statement was false, that falsehood was not material because my uncle was legally eligible to possess a firearm. So I'd like to take those two arguments in order.
As for the first, are there two buyers, in your view?
I think in a sense you could understand there to be two buyers. The buyer who counts under the statute, though, is the actual buyer.
Well, what does the person who's buying for somebody else, he has to provide both names or just the name of the real buyer?
Justice Scalia, if you hypothesize a situation in which two roommates wanted to buy a firearm together, firearms are expensive, they can't each afford their own, but they want one for personal protection. And if one went into the store and said, I'm buying this firearm for myself and my roommate who's not here, that transaction could not lawfully go forward because the two buyers of the firearm weren't in the store and they weren't physically present and they didn't go through all the statutory screening processes.
And both of them had to take possession, right? Right.
In that sense, right, because the whole...
But that's not the case here. The person who paid took possession.
Yeah, the person who paid took possession. They then brought that gun to their uncle in the uncle's state and had a background check run on his uncle and transfer the firearm. Why in the hell they're going through some of these tortured ass arguments trying to uphold this decision is just baffling.
Was authorized to take possession.
In the straw purchaser cases, the person takes possession in an ephemeral sense. They are merely the conduit. The purpose and effect of the transaction is to deliver that firearm to someone else.
So where in this — I'm sorry.
So there are two buyers, and both of them have to be on the form.
If there are two buyers, if two people of roommates are buying,
a straw buyer.
They would each need to...
I can understand you're saying the real buyer is the person who put up the money.
Well, of course, the form tells you who the real buyer is, and it's a substance over form inquiry. And we think this is supported by not only the text, but also the structure and purpose of the Gun Control Act.
Where in the Act is the basis for the requirement on the form? The form says, if you're not the actual person, you're buying for somebody else, blah, blah. Where is that in the statute?
That is ATF's reasonable interpretation of the statute, and I was just going to get to that.
It's current one. It used to have.
So I'll pause right here. Bacon and Bull Rush, you guys showing up. This case is a straw purchaser case. This guy was charged as being a straw purchaser because he bought a gun for his uncle in Virginia. And then he brought the gun to his uncle in Pennsylvania, had a background check run on his uncle, transferred the gun to his uncle in Pennsylvania. This case is course, this was 2014, made it all the way up to the Supreme Court because they were trying to put this guy in prison as a straw purchaser.
Have a different one.
That's the current one, and that's been consistent for the last 20 years, Justice Scalia. So the statute, we think both the text and the structure and purpose support this view. The text is most readily identifiable in Section 922A6 itself, which this Court in Huddleston
A6?
922A6, which is the count one of the conviction. It's the false statement provision at issue here. And this is quoted at pages 1 through 2 of the government's brief. So the provision says it shall be unlawful for any person in connection with the acquisition or attempted acquisition of a firearm, and it goes on. And at the end it talks about the lawfulness of the sale or other disposition of such firearm. This case isn't the first one in which the Court has had occasion to interpret those terms. In Huddleston, the Court looked at those terms, in particular acquisition and disposition, and it said several things about those terms that are relevant here.
Yeah, Bull Rush, they're charging him as a straw purchase because they're saying that he lied on the 4473 when he answered the question about if he was the intended purchaser of the gun. It doesn't matter to the government that there was a background check run on his uncle, that his uncle was not a prohibited possessor. All that matters is that question on that 4473. That's how asinine this stuff is.
It said those terms are meant to have a practical, common sense meaning in terms of who will become into possession and control of a firearm as the result of a transaction with a federally regulated dealer. And they don't turn on formal notions of legal title. And that with respect to disposition in particular, that Congress meant to give broad effect to this term. And so we think that the same kind of practical, common sense inquiry is applicable here. When looking at the transaction, the question is, what is the ultimate purpose and effect of this transaction? Is it to have someone else acquire the firearm?
You brought it isn't the language. His point is that I think that the statute, it has to be material to the lawfulness of the sale. Now we look to see what section is it material to. And you say in your brief it's material to the section that says, you have two of them, but they come to the same thing, selling or delivering any firearm to any person. All right? Now he says, did they sell or deliver this firearm to what you call the real purchaser? He says, no. They sold or delivered it to the straw. And that's the end of the matter.
Oh, God, man, this guy is such a moron. But, yeah, you're right. I mean, it's just, how can they prove intent of the buyer? I mean, with this guy, with Abramsky, he was to go short on the whole story. He was under investigation for some other stuff. They searched his home. They found where he had purchased the firearm, and then they found out that his uncle sent him a check for the cost of the firearm because he told his uncle he could get the firearm for a much cheaper price than where his uncle could get it. And I think it was a Glock. I can't remember the model of it. So they pretty much had that end of it locked down. It doesn't matter to them that he was a legal gun owner. It doesn't matter that his uncle was a legal gun owner. All that matters to them is, well, he didn't tell the truth to the government. That's literally the whole basis for this. And this court in 2014 upheld this conviction. Is it bull? They could have got him under the same thing. See, they don't give like a period of time you would have to have a firearm before you could transfer it to someone else and not be a straw purchaser. There's no listed period of time for that.
And at least the statute is open to this interpretation, and it's a criminal statute. And besides, the ATF for a long time interpreted it that way. So what we should do is interpret it strictly. Now, that's, I think, the basis of their argument, if I understand it. And so you have to get those words sale and deliver and explain how in the criminal statute they apply to what you're calling the real purchaser.
Right, Justice Breyer. The statute uses a number of different terms to connote what we take to be a substance over form inquiry into the actual possession and control of the firearm. So in 922A6, as we were just talking about, it talks about acquisition, sale, or disposition.
But you also
In
quote
1922A5
material, the need for it to be material to the lawfulness of the sale.
Correct.
You seem to concede that in the brief. It has to be
Yes.
material, and there are two sections, and both come to the same thing, which is what I said.
So this is where we get back to the fact that there are two different issues in this case. If I convince you that there was a false statement here because petitioner's uncle was the actual purchaser,
If he is the actual purchaser,
Yeah.
then he falls within the term of a person to whom the firearm was sold or delivered. That's your argument.
and his name wasn't put on the form.
Oh, there's no question about that.
Right. So if I could just finish one other thought on this first issue of falsity.
So his name wasn't put on the original form. His name, however, was put on the form when the gun was transferred to him. And this guy still gets charged as a straw purchaser.
And as Justice Sotomayor and Justice Alito's hypotheticals demonstrated, under petitioner's view of the statute, I could approach someone in the parking lot outside of a licensed dealer. I could say, would you like to make a quick buck? Please come in with me. I could point to the firearm I want. I could hand him the money. I could look over his shoulder as he fills out Form 4473 in his own name. I could watch the dealer run that person's name and identity through the criminal background check. And as we leave the shop together, he could hand me that firearm.
Yes, you could do that. Now, as long as he's not handing the firearm to a prohibited possessor, then there shouldn't be any issue in that scenario. If I, as someone who's not necessarily a fan of the government, don't want them knowing what I purchase and I had someone else purchase a firearm for me, that shouldn't even be an issue because I'm not a prohibited possessor. That's how stupid this background check system is.
Why is that any more horrible than the notion that as soon as I buy it, I walk out of the store and I meet this guy in the parking lot. He says, hey, that's a nifty looking gun there. How much did you pay for it? He says, I paid $600. I'll give you $700. Oh, it's yours. Right? I can hand it to him, can't I?
You could, Justice.
So the notion that the gun would somehow get into the hands of somebody who wasn't registered or who couldn't buy it himself, I mean, that's going to happen anyway. What you assert does not stop that problem.
Justice Scalia, Congress was obviously balancing a number of interests when it enacted these provisions.
Congress is filled with a bunch of morons. And yeah, but it should be that a straw purchase is concerned with someone buying a gun for someone who is prohibited. That should be the definition of a straw purchase. However, that's not. The definition of a straw purchase is merely me buying a gun for someone else. Now, that could also be that I find a good deal on a gun. I purchase that gun because I know I can flip that gun for more money. That makes me a straw purchaser.
If you read the text of the statute and the legislative history, it's clear that Congress thought the principal problem was effectively unregulated sales of firearms from dealers. That's the problem it wanted to focus on. And you're right that it didn't want to go further and intrude on private transactions among unlicensed individuals. It drew a line, but it drew a line at a point where it thought the actual problem was. And that line was up to and including the point of sale.
But, Mr. Palmer, when the agency changed its view in 1994, there was no change in the statutory text, was there?
There was not, Justice Ginsburg.
And at that time, the interpretation was that you committed the offense if you sold, if the person, the true buyer, was an unlawful, a person to whom firearms could not be sold. But if the ultimate possessor was a lawful possessor, then there was no liability. So the statute has to be open at least to either interpretation. No change in the words. The agency read it one way and then later changed its mind and read it the other way.
And there's what she's talking about is the ATF's interpretation or their rules on this. And we all know, especially at this point, if you're paying attention, the ATF loves to change their mind on stuff that has basically been legal for decades. And that's what they did with this. Shitty written laws and giving an agency the authority to basically interpret that law any way they see fit. This is insanity squared.
That's right, Justice Ginsburg. And I think that takes us to the second issue here, which is the materiality issue. And I think what happened was that the agency's earlier view of the statute was essentially overtaken by the case law in several respects. And the agency therefore updated its view and has consistently applied that view for the last 20 years.
Yeah, but still, look, what I thought was a very good argument on your side is exactly what I said of the narrow interpretation would also apply to a straw man who buys a gun for Al Capone. And so this part of the statute would be virtually worthless. Their response to that is, don't worry about that. There are plenty of other provisions that will take care of that. Are there? And if it's so obvious about the Al Capone, why did the ATF decide it their way for 20 years? I mean, how did they get into that?
Justice Breyer, I think that the other provisions that Petitioner is referring to is 922D, which makes it unlawful for anyone, licensed or unlicensed, to transfer a firearm to someone in a prohibited category if the transferor knows or has reasonable cause to believe that the person is in a prohibited category.
And see, that's where they'll stick you on this right now. The has cause to know or reasonable cause to believe. You're going to start seeing cases, and I will bet money on it, where there's a person-to-person transfer without a background check, person-to-person sale, which is completely legal in a lot of states. And if something was ever, or crime was ever committed with that gun, they're going to come after you for selling that gun. And they're going to say that you should have known this person was a probable felon because they were going through a sale without a background check in the first place. That's how retarded this stuff gets. And yeah, the ATF, it's not their job to interpret laws, but they can make rules and regulations, which is what they did with this, which has this guy, which I think he pled it out. He served like 5 years probation or something and paid some fines for this stuff. So he was lucky. He fought it. Obviously, it made it all the way up to the Supreme Court. For a lot of your average people trapped up in this shit, they're just going straight to prison.
Category. And that is a completely inadequate substitute for what the kind of regulation we're talking here for a variety of reasons. One is the mens rea requirement that I just mentioned. So in my hypothetical involving the parking lot, the straw purchaser doesn't even know my name, much less anything about my background, whether I was dishonorably discharged from the military, whether I had mental health issues, doesn't know anything about me. He has no reason to ask. I certainly have no motivation to tell him. And yet that transaction can go forward, and it'd be very difficult to prosecute that straw purchaser for an illegal transfer if it turned out that I was a felon. Second is the whole purpose of this structure of this statute, especially after it was amended in the early 90s, was to put in place and reinforce a dealer-based regulatory system in which the eligibility of firearm transferees is determined based on a search through a database. We don't take even the transferees say so as to whether or not he's an eligible person. He has to fill out the form.
It's very problematic to talk about the overriding purpose when you're dealing with a very sensitive compromise. There's, as far as I can tell, nothing in the language of the statute that talks about straw men or actual buyers or anything like that.
You're right, Your Honor, just as there's nothing in the mail or wire fraud statute that talks about Ponzi schemes. That a Ponzi scheme is simply
There wasn't a strong lobby in Congress saying we're the group that supports Ponzi schemes. So maybe it makes more sense to have a broad construction of that provision. This language is fought over tooth and nail by people on the gun control side and the gun ownership side.
Yeah, this stuff was fought over tooth and nail, and the NRA basically caved all that crap. I mean, and supported this background check system. So another reason that I've always said I would never be a member of the NRA. They are a weak-ass organization. They always have been. and they certainly are now.
And to say, you look at it and say, well, the purpose is this, even though there's no words in the statute that have anything to do with straw purchasers, I think is very problematic.
Well, Your Honor, I think we do have a textual argument, which I referred to before, but there's also, it's not just a purpose argument, it's a contextual and structural argument, and it's the one that Justice Alito alluded to in his
But you agree that in Justice Alito's example, that person is regulated as a gun dealer, right?
At a certain point, a person, if they're operating
The yellow
as-
pages.
right, if they're operating as a seller of firearms, they would have to register.
Well, I amend my hypothetical. So he doesn't put it in the yellow pages and he doesn't put it on the internet. He just hangs around in the parking lot of Joe's to accommodate people who, and Joe's is near the border, and he wants to accommodate people who may wish to employ him as a straw purchaser.
Right.
You wouldn't think of prosecuting him, would you?
I mean,
Again, they're getting into arguments that have no bearing on this case whatsoever. None. And at this time, the court was basically a way left-leaning court. This was in 2014, so that didn't change until Trump was in office and then got a couple picks on the Supreme Court. So the dissent on this case was written by Clarence Thomas and Alito, and I think even Roberts might have signed on to the dissent, and Scalia. But this whole case is absolutely ridiculous.
At a certain point, if the conduct is so pervasive and regular, if he's acting as a dealer, then you might be able to get him on that separate provision. But you're right, before that point, you wouldn't necessarily be able to, and that would be a perfectly lawful conduct. And it's also important to talk, we were talking, Justice Breyer, about...
Before you go on, I wanted to get back to the Al Capone hypothetical. As I understand Petitioner's case here, I don't think he's asserting that if Al Capone, if he intended to transfer it to Al Capone, that his statement would not have been material. His position is, since I intended to transfer it to somebody who could lawfully possess it, the statement was immaterial.
And my point, Justice Scalia, is that in a straw purchase context, you're not necessarily going to know you're dealing with Al Capone or someone of his record. These are often cases in which people have an ephemeral relationship. They may not even know each other's names.
Well, Mr. Palmore, is that right? I thought that Mr. Dietz's argument went beyond what Justice Scalia just said, that for Mr. Dietz, he might be prosecuted under another statute for selling something to somebody he knows as Al Capone, but that he would be, because he was the guy at the counter and he was buying for somebody else, as to this question of material representation, it does not matter whether the ultimate transferee was Al Capone or somebody else.
I think that's right, Justice Kagan, and that's his first argument, and what I take to be his main submission is essentially that his statement was true.
I think he said that just right up here.
It was true, so you don't even get to the materiality question. So that's right. That subsequent transfer might separately be a violation if he knows or has reasonable cause to believe that the transferee is in a prohibited category.
But he did the transfer to his uncle at an FFL with a background check run on his uncle. So he didn't transfer it to anybody he thought was a prohibited person, could be a prohibited person, was a prohibited person. None of that is even material to this case. The only thing that the government and the government's lawyer, who is the one talking now, and these other justices, these left-leaning dipshits, are even worried about is the fact that he purchased a gun for someone else.
I would just point out, though, that that would not have been the case from 1968 to 1986, because 922D, which prohibits transfers to ineligible transferees, applied only to licensed dealers until 1986. It didn't apply to private individuals. So the kind of straw purchase on behalf of Al Capone, as I understand it under Petitioner's theory, would have been perfectly legal from 1968 to 1988.
Yeah, because I could buy a gun, have a gun, and then sell that gun in a person-to-person transfer to someone who looks completely on the up and up, doesn't show any red flags of being a prohibited possessor. However, if they are caught with that gun and that gun is tracked back to me and they are a prohibited possessor, I get charged. Felony, prison time. That's why that exception was there before that didn't have that illegality built into it, because people understood that if I do a person-to-person transfer, I'm not responsible for what that person does with the gun.
86, even if it was knowing. Justice Ginsburg, we talked a little bit before about how ATF's view kind of caught up with the case law. And I think some of that case law is actually quite helpful here for illuminating the materiality question. And it's the Crandall case from the First Circuit that we talk about in the brief. If petitioner is correct that the materiality of a false statement turns on whether the ultimate, in this context, whether the ultimate purchaser or the actual transferee of the firearm was eligible or not, it's unclear why someone seeking to buy a gun from a federally regulated dealer couldn't go in, provide a false name, and provide a false identification, and receive a gun, and then if he's prosecuted for that false statement, he could defend, as the defendant in Crandall tried to defend, saying, well, it didn't really matter because I'm actually eligible. So even if you'd known my true name and had my true non-forged ID, you would have sold me the gun, so it's not.
That is one of the most idiotic arguments that I've heard in a long time. One, saying that, well, this person could have lied on their 4473, used a false identification, all that. Okay, having the false identification and all that is a felony by itself. Fuck me running, man. These people are goddamn retarded.
Material. The courts of appeals and the lower courts have consistently rejected that argument. And what those courts hold is that in all cases, the lawfulness of the sale of a firearm from a regulated dealer is contingent on the recording, confirming, and after 1993, screening of the identity of the purchaser.
And this now you're talking about the second question.
Correct.
And the provision that makes the information that's required, makes it material, correct me if I'm wrong, is 922B5, right? That's what
one of the
requires
provisions.
that. Okay, now all that says is you have to keep the information of the person to whom you're transferring the firearm. So your argument has to be when somebody sees the person, they realize that that means not somebody who's buying it for somebody else, right?
Right. And if you're with me on the straw purchase idea that this was a false statement because the purpose and effect of the transaction was for the uncle to acquire the firearm, then that was a false statement. Then the actual
yes, I know. If I assume you're right, then you're right.
If you assume I'm right on issue 1, then I think the materiality on issue 2 follows directly from this provision that you've quoted, 920.
Freaking the insanity just keeps coming. Now, I realize this guy talking right now is the government's lawyer, so he's going to push the government's case. But realize they've only got more radical since this time in 2014. So if you think they wouldn't put your ass in prison for buying a gun and then selling it to someone else without a background check, you're fucking dead ass wrong. Yeah, anybody who's not a licensed dealer, who's not running background checks, when they sell a firearm, you might as well just hook it up as a straw purchaser. That's how you could be charged. So again, if I buy a gun that I find a good deal on, that I want to flip that gun for more money, I'm a straw purchaser.
To B5. And I think
because then person, carries with it the concept of not just the person to whom it's transferred, which is what 922B5 says, but the fact that it has to be the actual person who ends up with the gun.
Yes, and I think the term needs to be looked at in context. It's not just 922B5. There's also 922T, which is the Brady provisions. And there it talks about transfer. So we talked before about how there are different terms that are used.
Well, 922T,
which says that you can't.
where is that?
This is on page 13. No, I apologize, Justice Scalia. There's not an appendix, but this is quoted in relevant part on page 13 of our brief. So 922T says that no transfer of a firearm can take place unless the identity of transferee is confirmed with a photo identification, and unless that identity is screened through a database to ensure that that person is eligible.
See, I would have thought that if you're right on question 1, 922T just makes this a slam dunk on question 2. And there's a question about whether you're right on question.
How does that make that a slam dunk, you fucking ignorant hag? He had a background check run on him. He had a background check run on his uncle when he transferred the firearm. The background check requirements were met. And this bitch is still on the Supreme Court right now.
But if you are, T says, look, the dealer is supposed to check the transferee, right? And if we assume that when Congress says the transferee, it's the real transferee, not the fake transferee, the dealer is supposed to check the real transferee. So what does the dealer think is material? I mean, the question is, what does a reasonable dealer think is material? I better know who you are so I can check you. That's material.
I think that's right, Justice Kagan. I think that anyone looking at 922B5, Chief Justice Roberts.
I can't look at all these things because they're not in your brief. I really.
Elena Kagan is the justice he's talking to right now. And again, she's still on the Supreme Court right now. She's another absolute leftist that doesn't give a flying fuck about the Constitution.
I really resent, especially in statutory cases, not having the statute in front of us. I shouldn't have to flip through your brief to see what page you cite a little snippet from one section of it.
You're right, Justice Scalia. I apologize for not including a fuller statutory appendix in this brief. But the point is of 922B5, when it asks for the name of the buyer, one would ask, well, what reason, why is this name relevant? Why is this question being asked? And this goes to Justice Alito's observation about the structure and purpose of the statute. This name is clearly being asked because Congress cared very much about preventing anonymous sales of firearms. It cared very
So see, and he's stating the government's case perfectly right there. The government cared about anonymous sales of firearms. That's all they're worried about.
Very much about having a record of who that first buyer was.
Well, it's not just the structure, it's not just the overriding purpose. 922T says that the dealer is supposed to check the transferee to find out whether the transferee has a criminal record, to find out whether the transferee has mental illness. So who does he check? Who is the transferee? Well, I need to know who the transferee is to make that check. So obviously it's material to know who the transferee is.
The transferee is the person taking possession of the firearms at the point of sale, you fucking moron. After that firearm is in their possession, it is their property. They should be able to do with it what they want. Fucking Christ, man.
I agree, because those requirements would be pointless if they could be satisfied.
But it's going to be the same problem, which is the straw, because the transferee in context probably refers to the person to whom the dealer transferred the weapon, namely the buyer. And does it apply, for example, if he knows that the buyer is going to give the weapon to another person? And you will say no. And he's not the transferee, the other person. You admit that, you say it. And so why is the person to whom the one who puts up the cash is going to later transfer the weapon is the same question as to whether he is really the purchaser. I just don't see a difference. And therefore I thought but you can explain to me why there's a difference. I'd like to know that. And I guess I'd like to bring you back to that issue, and I'd just like to know how the ATF reached the contrary conclusion.
the ATF reached the contrary conclusion just because they pulled that decision straight out of their ass. Fucking Byer is an absolute moron. Having him off the court would be a great thing if you replaced him with someone who actually respected the Constitution. However, that's not what is going to happen. He's going to retire here in the next little bit, and Biden's already put out his pick for the next Supreme Court justice, and she's going to be worse on firearms than Byer was.
Conclusion, if it would so undermine the statute.
Well, Justice Breyer, a couple points about this. One, as we talked about before, we think Huddleston suggests that these terms, and Huddleston was interpreting acquisition and disposition, and it was stressed that these had a practical, common sense meaning about who was going to obtain possession or control of the firearm as a result of the transaction, as a direct result of the transaction.
And what about the donee?
The ATF has never interpreted this provision to prohibit gifts, and a gift recipient is in no sense a party to the gift giver's purchase of the gift. That's just not the way we think of gifts. The purchaser may change his mind. The purchaser is not acting at the direction and control of the gift recipient. And in ATF's experience, there's not a problem with gift recipients.
You don't think that
So realize in a very real situation, to use an example, I could be working out of town and there's a certain gun that I want, and I send my buddy the money and I tell my buddy, hey, this is a great deal on this gun. Do me a favor and go pick that gun up for me. That makes him a straw purchaser. That could put him in prison. Even though in using that example, I'm not a prohibited person, neither is my buddy. The government's only concern is that question on that 4473, which could be solved very easily by adding in another section there that says, I am buying this as a gift, or I am buying this for another person. But they don't want to make that easy. They don't want to make that clear cut.
crime bosses,
Guns. I'm sorry.
you don't think crime bosses look at their underlings, pay them a lot of money for whatever they're doing, and just say, go get me a gun and give it to me?
Again, not what happened here, you fucking retard. Criminals get guns through various sources. They steal them. They sell them on the black market. In case this dumb hag does not realize this already, this background check system has not stopped a single felony from getting a damn firearm. Fucking Christ, man.
Well, I think that I would suggest that wouldn't be a gift under that scenario, Justice Sotomayor. If that person is working for the crime boss and it's part of his duties to go obtain a gun, then he's buying that gun on behalf of the crime boss.
Could you answer Justice Kennedy's question? Is this all contingent on the intent at the moment? I mean, you had a lovely wrapped case here because you had the money transferred before the purchaser, so there's no question that the intent was to purchase for the uncle. But what about the situation where there's a conversation beforehand that says, I'm going to buy the gun and I'll sell it to you afterwards?
I think the question, there could be a factual question in some of these cases. The question would be, was that purchase made on behalf of someone else? There's no factual issue here. This was a guilty plea, so we have to assume that this transaction was made on behalf of the uncle. As a factual matter, petitioner disputes whether that matters legally or not. And
I'm not sure what you mean. I gave you a hypothetical.
right, and
why is it a
in your
factual?
hypothetical, I think that would be a straw purchase. That purchase was made, even if the money was going to come later, that purchase was made on behalf of the absent party, and it can't proceed for a variety of reasons.
This is a criminal statute, and you're saying that when I buy it and I've told somebody I'll sell it to you later, that I am acting as an agent? And wow.
Yeah, that's exactly what they're treating this as. Exactly what they're treating this as. So, again, use the example. I buy a gun. I'm walking out of the gun store and someone says, hey, I was just going to buy that. That's the last one they had on the shelf. I will pay you $100 more than what you paid for it. And I sell that gun to them. I am a straw purchaser. Now, there is no period of time where they say that I can possess that firearm before I sell it to not be a straw purchaser. That's how absolutely diluted this argument is. Yeah, Bob, this guy was looking down the barrel of, I think, like 10 years and a $250,000 fine. He pled out to a couple of years of probation. And then they went back and fought this. This is the Supreme Court argument because lower courts actually upheld this absolutely moronic conviction.
Criminal statute.
Justice Scalia, in Huddleston is helpful in this regard, too. There was a notice rule of lenity argument made there because the person in that case wasn't actually buying the firearm. He had pawned it to the pawn shop and he was redeeming it. And he came in and said, I'm not buying it. I'm just getting my own property back. I'm not buying it or acquiring it. And the court relied, in rejecting that argument, relied in part on Form 4473 because it provided notice that he had to check these boxes and had to truthfully answer the question. I think it's rare that you get a case with this degree of notice when the defendant is actually committing the offense and making the false statement. He's told in bold letters right in front of him not to do what he's about to do, and it includes a hypothetical.
Well, he's not told that in the statute. He's told that in a form that was quite different from the form that was used before.
That's right, Chief Justice Roberts. It's a form that's been used consistently for 20 years. And
it's a form that the ATF and the Attorney General came up with and is used just like a law would be used. I mean, you're basically swearing out a statement to the government on a 4473 to be truthful. This whole thing is just ridiculous. And the more these idiots actually argue this, and you understand that the Supreme Court at this time was heavily left-leaning justices that don't give a shit about the Constitution, you can see how they upheld this decision. And I think Kagan is the one who actually wrote the decision for the Supreme Court in this case.
And for the reasons that we've said, we think that the current view of the ATF and the express instructions on the form are actually the most consistent with the statute, because the statute requires identification of a firearm purchaser to be recorded, confirmed, and screened in every case. That's not contingent on the person turning out to be eligible or not. Congress wanted to prevent anonymous sales of firearms, and it had it.
So again, that's where he gets into it. The real argument behind this. Congress wanted to stop any kind of anonymous sales where the government couldn't track the location of that firearm. That's all this was about.
Purpose, obviously, to keep
As
out
to
of
whether or not there was a sale, suppose the facts in this case, and it was a Glock, I think,
yes,
was delivered, and suddenly Abramsky finds that it's a valuable collector's item. There were only 2 or 3 of these made. It had a special trigger or something, and it's now immensely valuable. Could the uncle insist that it be sold to him for the $700? Or for the agreed price, for the $400 thing?
I think it's not clear, Justice Kennedy. There might,
well, if it
might be a contract.
If it isn't,
between
then there
them.
wasn't. Then there was a subsequent sale.
Right, but of course here there's no subsequent sale because the check was written before.
Well, I'm asking about that.
Right. I think if the petitioner changed his mind and decided not to actually transfer it, I think as a technical matter that wouldn't affect the legality, because what mattered was he making a purchase on behalf of another and entering a false statement at the time.
What mattered is he did not answer truthfully on a government form. And that's all these idiots are worried about.
He made it. A fact question could arise in a situation like that, which a defendant could argue, I wasn't actually making the purchase on behalf of someone else, and that argument is supported by subsequent events. But I think I was about to say that the one critical purpose of the statute obviously was to keep firearms out of the hands of ineligible persons, but another critical purpose was to allow for the tracing of firearms and to prevent the anonymous stockpiling of firearms. And with respect to that purpose, I think
So listen to what his deal was there. To prevent the anonymous stockpiling of firearms. In other words, again, they want the government to be able to track every single firearm, where those firearms are at, who owns those firearms at all times. He's admitting the government's conditions or their case on this. And yeah, you're right, Vanessa. These 9 people up here are the most powerful people in this country. Now, you can gift a firearm to someone. There are exceptions to who you can give a firearm, who you can gift it to. Could they still come after you for a straw purchase? By the state's logic in this case, yeah, they could.
Facts of some of the cases underlying the circuit split on the second issue of materiality are quite salient. Those are all cases in which eligible parties wanted to anonymously obtain large quantities of firearms for illicit reasons. They were eligible, but they wanted to not have their name associated with the transaction. So Polk, which is the Fifth Circuit case, which is actually on petitioner's side, that person wanted to anonymously acquire firearms to create a stockpile to attack an IRS building, to kill police officers, and to assassinate a judge. But he was eligible. In Frazier and Morales, which are the 11th and 6th Circuit cases addressing this materiality issue, they were straw purchases on behalf of eligible buyers, but they were, again, wanting to anonymously stockpile weapons and not have their names associated with them because they were smuggling them out of the country. And
see, he's bringing up another freaking case right here that has no bearing on the original case. If someone wants to stockpile weapons and then smuggle them out of the country, well, that's covered by ITAR. That's a whole nother section of law that is absolutely illegal. Why in the hell we're even getting into that argument in this case is absolutely moronic. Yeah, no cameras in any federal courts, much less the Supreme Court, which again is another absolutely moronic thing.
Petitioner's view of the statute in which a straw purchaser can satisfy the requirement that the first transaction at the point of sale be recorded would completely satisfy the statutory requirements, would greatly impair the ability of ATF to trace firearms and to have an accurate record of who that first purchaser of the firearm was. If there are no further questions, we'd ask that the judgment of the Court of Appeals be affirmed.
Thank you, counsel. Mr. Dietz, you have 4 minutes.
So this is the defense attorney's rebuttal that we're getting to now.
Justice Ginsburg, you asked counsel whether this was a case where there were 2 interpretations of the statute. Counsel conceded that there were. I think that's an important point because, of course, we're dealing with a criminal statute. If there are 2 interpretations under very well-settled precedent from this Court, the Court applies the interpretation that's favorable to the criminal defendant, and that's part of the doctrine of criminal law. Justice Kennedy, you mentioned the agency situation that existed here between Mr. Abramsky and his uncle. And here, I think it's important to note that there wasn't even any consideration. This was truly a purchase. It was just a favor for a family member. And the government, in order to advance this straw purchaser theory that historically came from civil common law, there needs to be a relationship between Mr. Abramsky and his uncle that is a fiduciary relationship where Mr. Abramsky is required to act in his uncle's best interests at all times. And that, for example, if he left the gun store and someone said, hey, did you just pick up a Glock, I'll buy it for you for $500, that Mr. Abramsky could not even enter into that sale without providing his uncle with any money he made from that sale. And there's a complex set of civil agency law principles that apply here that just don't translate to this straw purchaser doctrine as we've described it. And I think that's a fundamental flaw in the government's theory, is that the courts just have never thought through all of the various situations that apply in these fiduciary relationships and how you would apply them to situations where you're just buying a gun for a family member or something of that nature.
And this is just more proof that, one, the current background check system is absolutely asinine in the first damn place. It hasn't stopped a single criminal from getting a firearm. Probably 90-something percent, 99% of all the purchases that are denied due to the background check system are all false positives. It's freaking stupid. And, you know, I used to believe in the background check system. I'll say that until I started looking at the entire system and started looking at the laws behind it and started looking at the effectiveness of the system, and it has proven to be absolutely moronic. But you have justices on this court that are still on the court to this day that just believe in the power of the state over the power of the individual. And they're always going to side with the government.
I also wanted to turn to the gift exception. There's also another exception the government acknowledges, and that's for raffles and contests at charities or political fundraisers. And so in that circumstance, the person who's buying the gun knows that they're giving it to a complete stranger and someone who by random chance wins the right to own the gun. But in those cases, the government says there's no need at the time that you buy the gun to take any steps to ensure there's record keeping or a background check on that person. And I think that undermines this idea that everyone receiving a gun as it's in the chain from the gun dealer, Congress wants to have a background check. Congress is concerned about providing enough information to allow for tracing and nothing more. And as a final point, Your Honors, I think perhaps the most important point is in this case is if the court rejects the straw purchaser doctrine as it applies in this case to a lawful gun owner buying for another, there are really no harmful consequences. The government retains a very robust toolbox of criminal statutes to prosecute illegal straw purchasers, those who buy guns to get them into the hands of prohibited persons. And the government will receive accurate, truthful information about that first sale so they can trace firearms when they're used in the commission of a crime. So the only thing the straw purchaser doctrine in this case really accomplishes is to prohibit law-abiding citizens from buying guns for other law-abiding citizens. And that's something that Congress expressly chose.
No, Vanessa, if you were had a family member in another state from where you reside, if you bought a rifle for them, then you could gift that firearm to them without a background check. If you did a pistol, you would have to run a background check on them in their state, because it's legal for me to go out into another state and buy a rifle and take possession of it same day. If I go out to another state and buy a handgun, I have to have that transferred to an FFL in my state to run a background check on me in my state before I can take possession of it.
Chose not to do, and we would ask this court to remain faithful to the statutory scheme actually enacted by Congress.
If we agreed with you on the second argument, would the government have to prove that the person to whom the straw purchaser transferred the gun was ineligible, or would it be a defense if it was shown that the person was eligible?
I think the government would have the burden there, Your Honor, and I think the government has suggested they provide an example of a circumstance.
Well, the government should have the burden to prove that in any case. And what's so ridiculous about this one is the guy, his uncle sent him the money, he bought the gun. He had a background check run when he bought the gun, but then he transferred the gun to his uncle in this uncle's state through a background check. Neither of them are prohibited possessors. Both of them are legal gun owners. And the state still put this guy on trial, trying to put him in prison for a straw transfer or a straw purchase.
Where the person who bought the gun was buying it for someone named, I believe, Almanio, who they had no idea who that was. But yes, in that circumstance, the government would need to prove that that person was prohibited. But I think in circumstances like that, where you're buying guns for someone you don't even know who that person is, the government may well have evidence in that case that you either knew or had reasonable cause to believe that that person was.
Yeah, Vanessa, the only reason you would have to run a background check on a handgun selling it to somebody in a person-to-person sale would be if that person resides in a state other than yours. Again, it goes back to the same rules if I'm buying a gun from an FFL. If I'm buying a rifle from an FFL, I can buy a rifle or a long gun in another state. They can run the background check. I can take possession of that in that state same day However, if I'm buying a handgun in another state, that gun has to be transferred to an FFL in my state before it is transferred to me. It goes to show more and more just how absolutely ignorant and asinine all these laws are. They're so freaking diluted. They don't stop a single criminal, but they will, however, if you make a mistake, they're going to throw you in prison over that shit.
Prohibited from possessing a gun.
Yeah, but the other purpose that they said this provision has is to get gun dealers to run checks. And you can't run a check if the name isn't there.
That's right, Ron. And of course, you can't run a check on someone who wins the gun in a raffle or.
Yeah, but the other problem, we're back to the language. They say your client, falls within the language, and you say he doesn't. You say, all right, great.
Thank you.
Thank you, counsel. Case is submitted.
So that's the end of that argument. And God, you guys that stuck around for that, you deserve like lots of Xanax and everything else. Definitely go drink some beers now that that's over, because there's a reason Bacon came up with the perfect name for these streams, which is Share the Pain, because that's exactly what this is. Oh, this stuff is just crazy. I haven't decided what the next one's going to be. I think I'm going to run it probably about the same time on a Sunday night. Try to keep up the theme with it. But yeah, it's just, oh God. When you actually get in and you look at a lot of these laws, when you read the text of laws that are coming in right now that Congress is actually pushing through, they're all basically designed to take your average person who is not a criminal and make them a criminal. And that's how the ATF rulings that are going to come out in this summer are going to be. They're going to take a bunch of people that aren't criminals and make them felons overnight, simply because the ATF changed their mind on something. And all these dumbasses that I have written letters to, whether it's Congress people in Alabama or all the federal people that I've written letters to, are absolutely full of shit. Matter of fact, I've got another one that I just got the other day, a response letter from a guy, or I think he's a representative from Alabama, who is the most it's the absolute most maddening milquetoast response I've gotten so far. It's an absolute form letter. Something mentioned the Second Amendment, and they just fire this freaking form letter out. Doesn't cover a damn topic I touched in this letter. Doesn't cover Matt from CRS. Doesn't cover Big Daddy Unlimited and wide open triggers. It doesn't cover any of that stuff. Doesn't cover the ATF's new proposed rule changes or their soon-to-be actual rule changes. None of it. Doesn't cover a single damn thing that I covered in my original letter to them. Vanessa, some states require you in a person-to-person sale to do NICS background checks. Others don't. In Alabama, where I'm at, I can sell a gun to someone else, no questions asked. It doesn't matter. I don't have to get a background check run. In some states, I think California, Massachusetts, they might have it in Virginia now. I'm not sure, when they push through all that other gun control shit. Where even as a person-to-person sale, you have to go through an FFL to do the transfer. So it's all in their universal background check stuff, which they're trying to push through federally. But the only way a universal background check works is if you know where every single firearm is, you know who has every single firearm, and you can track the movement of those firearms. So without a firearms registration, that universal background check would be as useless as the background checks we have now, if not even more useless. It's just absolutely insane. And the government's argument in this whole case is they really want to be able to track these firearms. It didn't matter that Abramsky was a legal gun owner. It didn't matter that he transferred the gun through an FFL to his uncle, who was a legal gun owner. None of that mattered to them. It was merely the fact that they could possibly lose track of that firearm. It's absolutely insane. Now, Abramsky, this guy is I haven't looked into everything with this guy, but this guy was a cop. He got fired from being a cop because they suspected him of a bank robbery. That's how the ATF and everybody else got involved in this. When they searched his home, they found the receipt for the firearm, and then they found the check from his uncle, and that's how they actually started to prosecute him as a straw purchaser. It's a crazy case. But either way, the guy's history doesn't matter. It's still the same case. He bought a gun. He went through an FFL, passed a background check. He transferred it to his uncle using an FFL background check, and they prosecuted him as a straw purchaser. What were you saying, Vanessa? All the feds gave us due. June, new Vegas published. Yeah, definitely this summer things are going to get even more stupid than they are now. And I don't know where a lot of this lands yet. Texas has an interesting case right now. If you guys have followed some of my videos, you know that I've went through it where the government uses the Interstate Commerce Clause to pass these firearms laws. If a product is manufactured in a state, sold in a state, and is not transferred to dealers outside of a state, it doesn't qualify as interacting in intrastate commerce. So the government has no right to regulate those items. Texas, with their suppressor bill, Texas said we are going to have companies manufacture suppressors in Texas to be sold in Texas. They won't be transferred out of state to other dealers. So the federal government can get fucked. They can't regulate these suppressors. The ATF tried a little pee-pee slap on them and said, yes, we can. And now the AG of Texas is suing, basically telling the ATF they can get screwed. So we'll see how that case goes. So I'm going to end that there, guys. And I'm going to go ahead and kill it and try to get me some sleep before I got to wake up in the morning, which isn't too long. So all you perps, take it easy. All you perps, be cool. And we will see you on the next one. Like I said, I think I'm going to do another stream, probably 11 or 12 Sunday night, going over another argument or another hearing, kind of like what we're looking at now. So you guys have your Xanax and Tylenol and beers and weed and everything else in line, because it's going to be another one that's going to be probably about as insane as this one. So all you guys take it easy. I am out. Y'all have a good night or good rest of the morning. Later.